Thank you for joining us for this fourth Race in the Law session. My name is Georgette Vigil. I am the Senior Director for Alumni Engagement and Outreach. A few items to note. Your screen name should be listed as your first and last name. If it isn't, please update your profile in video settings. Your first and last name allows us to identify you so that you will receive credit and your CLE affidavit. You are invited to introduce yourself using the chat function by typing your name, grad year, and anything you would like to share. This meeting is an interactive session, and following the Q&A, you will be randomly assigned breakout rooms to discuss the topics outlined in your program at cu.law/program. You can chat your questions using the chat function during the presentation. Professor Helen Norton will respond to questions following the presentation. Now it is my pleasure to introduce the Dean of Colorado Law. Dean Anaya is an internationally recognized scholar and author in international human rights and issues concerning Indigenous peoples. He served as the United Nations Special Rapporteur on Rights of Indigenous Peoples from 2008 to 2014. In addition to his teaching and scholarship, Dean Anaya has litigated major cases involving Indigenous peoples' human rights in domestic and international tribunals. Please join me in welcoming Dean Anaya.
Thank you, Georgette. Hello, everybody. I hope you're all doing well. And thank you for joining us for a lecture and discussion in our Race and the Law series featuring Professor Helen Norton. I want to give a special shout out to all of our students who are participating and who are on the eve of their exams. We wish you all the best of luck with the exams. And before we go any further, I'd like to recognize that the University of Colorado sits upon land within the Ute, Cheyenne, and Arapaho peoples' traditional territories. And further, we acknowledge that 48 contemporary tribal nations are historically tied to the lands that make up the state of Colorado. The Race in the Law lecture series is part of Colorado Law's Anti-Racism and Representation Initiative, which we launched this past July. An overarching goal of the initiative is to enhance opportunities for learning and reflecting on racism and its effects, and on what each of us can do to work to defeat it as lawyers or future lawyers and citizens. And we're pursuing this goal in part through this lecture series. Other overarching goals of the initiative are to expand the law school's role as a catalyst for a direct action to combat racism and its manifestations around us, and to enhance the representation and inclusion of people of color and others from marginalized groups within our law school and the legal profession. If you're interested in learning more about the initiative and our progress with it, I encourage you to take a look at our website at coloradolaw.edu/law. It's now my pleasure to introduce Professor Helen Norton, who will be presenting on race and the Constitution. Professor Norton's impressive background includes serving as Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice and as Director of Legal and Public Policy at the National Partnership for Women and Families. She served as leader of President-elect Obama's transition team, charged with reviewing the Equal Employment Opportunity Commission, and is frequently invited to testify before Congress and federal agencies on civil rights law and policy issues. She joined the faculty of Colorado Law in 2007 and currently holds the Ira C. Rothgerber Chair in Constitutional Law. Professor Norton's scholarly and teaching interests include constitutional law, especially free speech and equality, and civil rights law. She has been honored with the Excellence in Teaching Award on multiple occasions and was appointed a University of Colorado Presidential Teaching Scholar in 2014. She holds a JD from the University of California, Berkeley School of Law, where she served as Associate Editor of the California Law Review, and a BA from Sandford University, where she graduated with distinction. You can find out more about Professor Norton's impressive background in the detailed biography that's been made available to you. I'm now delighted to turn the program over to Professor Helen Norton.
Thank you, Dean Anaya, for that very kind introduction. And good morning, everyone. Thank you for joining us today. I'm going to share my screen. I'll count on you to let me know if you can't see it. So today I want to talk a little bit about what the Constitution's text does and doesn't say about race and equality. I want to talk about the interpretive choices that this thus presents to us in understanding the Constitution's relationship with equality. And I want to talk about what this means for ongoing debates about courts and policymakers' ability to address racial inequality. Now, given the limits of our time today, I'm going to focus on two examples of these sorts of hugely important interpretive choices. The first is a historical one involving debates before the Civil War on the meaning of the original unamended Constitution with respect to slavery. And the second involves contemporary debates today, over the meaning of the 14th Amendment and its guarantee of equal protection. The Constitution, of course, was originally drafted in 1787, ratified in 1788, and became effective in 1789, more than 150 years after the introduction of slavery to America. The framers of the Constitution, a document ostensibly devoted to principles of freedom and self-government, produced a document with compromises that protected, preserved, and rewarded slavery, even while avoiding express mention of slavery or race. I'm going to focus on three specific provisions in the original Constitution. The first is what's often known as the 3/5 Clause. The Constitution replaced the failed Articles of Confederation, which had governed the United States for the first few years of its existence. And under the Articles of Confederation, the amount of tax that Congress was permitted to request, not demand, but request, from each state turned on the state's population. And for those purposes, the Articles of Confederation counted each enslaved African American as 3/5 of a person. In other words, under the Articles of Confederation, the more African Americans enslaved within a state, the more taxes that Congress could request from that state. So as a practical matter, this penalized Southern states for slavery. Now, the Constitution, of course, replaced the Articles of Confederation. It borrowed the taxing provision I just mentioned, even though the federal government never implemented it, never assessed direct taxes against the state. But it added a brand new provision, this is the one that I'm showing you now, that based a state's representation in the House of Representatives, and thus also in the Electoral College, on the state's population, and counted each enslaved African American within a state's borders as 3/5 of a person for representation purposes. In other words, under the new Constitution, the more African Americans enslaved within a state's borders, the greater that state's power in Congress and also in the Electoral College that chooses the president. Recall that the number of electors a state has is the number of the state senators, always 2, plus the number of that state's representatives in the House, which depends on the state's population. So the framers' decision to choose the president through the Electoral College was made in part to advantage Southern states that had enslaved many African Americans and were getting representation credit for that. So the Electoral College gave slave states disproportionate power in determining the president. The new Constitution gave Southern slave states greater power precisely because they enslaved African Americans. And we're talking about a significant amount of additional power. In some Southern states, nearly half of their population was comprised of enslaved African Americans. So as legal scholar Lawrence Tribe has observed, the 3/5 Clause not only dehumanized African Americans, but it also rewarded their oppressors. Now note in this text here, we don't actually see, I'll come back to this later, we don't actually see any mention of the word slave or race or Africans. It talks about persons, free persons, and 3/5 of other persons. I'll come back to that later. second of the three clauses I want to talk about is what's often called the fugitive slave clause. But again, the foreign slave clause. But again, note that it doesn't actually use the word slave or race or Africans. But the purpose of this clause was to forbid Congress from stopping importation of enslaved African Americans before the year 1808. In other words, this provision protected the foreign slave trade from congressional regulation for at least a generation. And again, note that the foreign trade in enslaved Africans increased the South's representation in both Congress and the Electoral College. And then the third of these provisions is what's called the fugitive slave clause. Although again, note that the term slave appears nowhere here. Instead, it says that no person held to service or labor in one state under the laws thereof, escaping into another, shall be discharged from such service or labor, but instead shall be delivered up on claim of the party to whom such service or labor may be due. The Supreme Court interpreted this provision in an 1842 case called Pennsylvania versus Prigg, which is a decision that is less famous than Dred Scott, which I'll talk about in a minute, but at least as pernicious. Pennsylvania, a free state, had passed a state law that prohibited from within its boundaries the forcible removal of African Americans alleged to have escaped slavery. The Supreme Court held that Pennsylvania's law violated the Fugitive Slave Clause. The court interpreted the Constitution to provide slaveholders with a right to seize and remove African Americans anywhere in the country, to prevent northern states from interfering with this practice within their borders, and to preempt state laws like Pennsylvania's that would have provided hearings for African Americans alleged to have escaped from slavery before bounty hunters could kidnap or otherwise remove them from the state. The Supreme Court's decision in Dred Scott is the most famous, or I should say infamous, example of its interpretation of the original Constitution with respect to slavery. Dred Scott was an enslaved African American whose owner brought him for a time from the slave state of Missouri to the free state of Illinois, and then the free territory that later became the state of Minnesota. Upon his return to Missouri, Mr. Scott filed suit for his freedom, arguing that he became free as a matter of law once he was taken to a jurisdiction that did not impose slavery. Mr. Scott brought his first claim in state court, Missouri State Court, under Missouri state law. Long-standing common law precedent, first in England and then in many states, including Missouri, supported Mr. Scott's position, and a jury of 12 white men applied Missouri law and declared Mr. Scott to be free under this precedent. But the Missouri Supreme Court rejected that precedent and reversed the verdict for Scott. When the slave owner Sandford later moved to New York, Mr. Scott's lawyer brought a new case in federal court on diversity jurisdiction grounds, which gives the federal courts jurisdiction to hear state law disputes between two citizens of different or diverse states. Sandford's argument was that even if Mr. Scott was free as a matter of state law, in other words, even if Mr. Scott's legal claim was correct, that federal courts didn't have jurisdiction to hear a dispute between citizens of different states because as an African American, Mr. Scott was not a citizen. So there were two issues before the Supreme Court. First, was Mr. Scott a citizen? And thus did federal courts have proper jurisdiction to hear his claim? And second, on the merits of his claim, did Mr. Scott become free as a matter of law when he was taken from a slave state to a free territory? On the first issue, the court held that African Americans could not be citizens as a legal matter, that Mr. Scott was thus not a citizen of Missouri, and thus the federal courts did not have jurisdiction to hear his claim. And to justify this conclusion, the majority relied on an originalist understanding of the Constitution, stating that the original readers and writers of the Constitution agreed that Blacks were inferior and subordinate, observing that slavery was a long-standing and unquestioned practice in the United States, and that the framers and their contemporaries had reached the conclusions, according to the majority, quote, that Blacks could justly and lawfully be reduced to slavery for their own benefit, end quote. The majority emphasized that the notion of equality appeared nowhere in the original Constitution, and that the mention of equality that does appear in the Declaration of Independence should be understood to exclude African Americans because of the drafters' own practice of enslaving African Americans. Next, even though it had just ruled that federal courts did not have diversity jurisdiction to decide the dispute on the merits, the court went on to decide the dispute on the merits. And it held that any congressional efforts to regulate slavery were unconstitutional because the Constitution protected the practice of slavery as a fundamental right. Under this view, Congress's ban of slavery in free territories like Minnesota was unconstitutional as a deprivation of slave owners' property without due process of law. And under this interpretation, a slave owner had a constitutional right to transport his, quote, property where he saw fit, and Congress did not have authority to prohibit slavery in the territories. Nowhere in this opinion does the majority consider the argument that the constitutional term property should be understood to exclude human beings. The majority assumed that the constitutional term property included enslaved African Americans because many framers and their contemporaries treated enslaved African Americans as property. Now note, however, that this is not the only way that one could interpret the original Constitution with respect to slavery. Recall when I went through the three provisions, the 3/5 clause, the foreign slave trade clause, the fugitive slave clause, none of them actually use the term slavery, nor do they make any mention of race or of Africans or African Americans. So this ambiguity raised the following legal question in the first half of the 19th century. What do we do with the fact that on one hand, these provisions sure look and sound like they're protecting slavery, but on the other hand, they don't actually mention slavery? Must we interpret them to protect slavery if they don't expressly refer to slavery? Abolitionists, among others, disagreed on this question. One approach was to interpret the original Constitution as protecting slavery because the framers' original intent was to preserve and protect slavery, even if they were not express in committing that intent to paper. This was certainly the view of the South, which interpreted the Constitution to protect slavery from any government regulation. As one of many examples of this view, in the 1830s and 1840s, Southern congressmen took the position that not only did the Constitution protect slavery from congressional regulation, but also that it was thus unconstitutional for Congress to talk about regulating, much less abolishing slavery. And among other things, those Southern congressmen sought to censure House member and former President John Quincy Adams for attempting to read anti-slavery petitions on the floor of Congress. Now, at the same time, again prior to the Civil War, many abolitionists, like William Lloyd Garrison, agreed that the original Constitution protected slavery, which led to his conclusion that we must treat the Constitution as a morally reprehensible document that should be amended or abandoned and replaced by a new Constitution. He urged that the Constitution be burned for its moral flaws. But prior to the Civil War, other abolitionists, like Frederick Douglass, pointed to the text's ambiguity in failing to expressly use the term slavery. And he noted that this gap in the text requires readers of that ambiguous text to choose among available interpretive approaches. He declined to choose originalism as an interpretive method, but instead urged that we choose to interpret the Constitution's ambiguous text in ways that maximize the document's justice and its morality. In other words, he argued that when the constitutional text is open-ended enough to allow for more than one plausible interpretation, we should always choose the most moral and just result of that ambiguity. And under this view, where the text is unclear, it should always be interpreted in favor of maximizing justice and expanding human rights, regardless of the framers' original intentions. So under Douglass's approach, for example, he would understand the 3/5 clause to refer to non-citizen immigrants rather than slaves. And he would understand the fugitive slave clause, again, which doesn't refer to slaves expressly, to apply to indentured servants. If the Constitution is silent with respect to slavery, at least in mentioning slavery in those terms, Douglass argued, Congress is free to abolish slavery. Now, the Supreme Court at the time took the first approach, as we've seen, with Pennsylvania versus Prigg and Dred Scott. And of course, those decisions obviously did not put an end to the ongoing national debate over slavery. Only the Civil War would do that. And for those who sometimes argue that the Civil War is not really about slavery, and for those who sometimes argue that our monuments to Confederate leaders are not really about race, I'd remind them of, among other things, the cornerstone speech delivered in 1861, shortly after the creation of and the secession by the Confederate States of America. This speech was made by Alexander Stephens, the vice president of the new Confederate States of America. And he explained that the Confederacy's cornerstone, quote, rests upon the great truth that the Negro is not equal to the white man, that slavery and subordination to the superior race is his natural and normal condition. This, our new government, he said, is the first in the history of the world based on this great physical, philosophical, and moral truth. The North's victory in the Civil War brought three hugely important amendments to the Constitution. The first is the 13th Amendment, ratified in 1865. It abolished slavery by any actor, governmental or non-governmental. And in fact, it's the only provision in today's Constitution that constrains folks other than the government. Everything else in the Constitution constrains the government and only the government. There used to be one other example, prohibition, which forbade the manufacture and sale of alcohol by all actors, governmental and non-governmental, but obviously that's no longer in the Constitution. Now, in abolishing slavery, the 13th Amendment also overturned the second of the court's holdings in Dred Scott. Recall that this was the holding that the Constitution protected slavery from government regulation. Now, although a huge step towards equality, freedom from slavery, abolishing slavery is not the same thing as equality. And in fact, both northern and southern states continued, following the ratification of the 13th Amendment, to discriminate on the basis of race in a variety of ways. For example, very quickly, southern states began enacting black codes, which prohibited renting to blacks, selling property to blacks, prohibited blacks from owning property, prohibited blacks from holding certain jobs, prohibited them from entering into contracts, and imposed punishment for certain crimes on blacks and only blacks. Lots of folks in the North were against slavery, but not necessarily for racial equality. Freedom and equality are related, but they're different. So this brought a push for an additional amendment, the 14th Amendment, ratified in 1868. And not until the 14th Amendment's ratification do we see for the first time an express constitutional commitment to equality. Section 1 provides that all persons born or naturalized in the United States are citizens of the United States and of the state where they reside. This overrules the first holding in Dred Scott, the holding that no African American could be a citizen for legal purposes. And separate sections of the 14th Amendment went much further, for example, by establishing that no state shall deny to any person within its jurisdiction the equal protection of the laws. This is that first textual commitment to equality. And note that the Equal Protection Clause, as well as the amendment's Due Process Clause, explicitly applies to any person, protects any person within the United States, not just citizens. 14th Amendment is another step forward towards equality. Now, while you might think entirely reasonably that the 14th Amendment's textual promise of equal protection of the laws should include the equal protection of the voting laws, that was not how everyone understood it at the time. And in fact, many in both the North and the South continued to resist equal voting rights to African Americans, describing voting as more of a privilege to be earned than a right to be recognized. And in response to this ongoing resistance, the 15th Amendment was eventually ratified in 1870, making clear that voting rights could not be denied on the basis of race. This was the first, and still the only, express use of the term race in the Constitution. Now, to be sure, these three Reconstruction amendments are hugely important steps forward in the struggle for racial equality. But they're also compromises, and they carry the limits of compromises. Let's go back to the 13th Amendment. It permits slavery and involuntary servitude still to be imposed as punishments for crimes. And this, for example, invited some southern states to use their criminal justice systems to reinstate slavery for African American defendants as a functional matter. The 14th Amendment says that no state shall deprive equal protection of the laws. This means it does not address the threats to equality posed by private, non-governmental actors. And the 15th Amendment doesn't provide an affirmative right to vote. Instead, it's a negative right to be preventing government from discriminating on the basis of race. This is not the same as a general right to access to the polls. This leaves states free to impose other sorts of restrictions on voting, which they did through poll taxes, and which they continue to do through onerous voter identification laws and registration requirements and other measures that effectively deny many Americans, disproportionately people of color, with equal opportunity to vote. But notwithstanding these important limitations, the Reconstruction Amendments for the first time provided a textual constitutional hook to address problems of race discrimination as a legal matter. The Supreme Court in the late 1800s and early 1900s, however, remained very hostile to these amendments and interpreted them so narrowly as to make them virtually toothless. Not until the mid-20th century did the court begin to interpret these amendments in a more robust and meaningful manner. And of course, there's still plenty of work to do. So now let's turn to a contemporary debate over the Constitution's relationship to racial equality. Courts, policymakers, and scholars have long divided over the question whether the 14th Amendment's Equal Protection Clause should be understood as driven by anti-subordination or instead by anti-classification values. And this difference underlies many of our contemporary debates, our contemporary differences in talking about equality. And one of my objectives for this talk is to make sure you leave this talk understanding the difference between these two approaches so you can identify them in action. Now, among the illustrations of this divide is the contrast between Justice Blackmun and Chief Justice Roberts when considering the constitutionality of public schools' consideration of race when seeking to address racial disparities in various educational contexts. Under an anti-subordination view of the Equal Protection Clause, what matters is the relationship between the government's action and long-standing subordination. Under this view, government action, including that which expressly considers race, does not violate the Equal Protection Clause when it seeks to reduce or end that subordination. And under this view, government actions that do perpetuate long-standing racial subordination violate the Equal Protection Clause, even if the government did not intend that effect. This approach, this anti-subordination approach, thus finds no moral or constitutional equivalence between a policy that's designed to perpetuate a caste system and one that seeks to eradicate that caste system. Under this approach, it's both morally wrong and unwise to ignore how race has made a difference and continues to make a difference in American life. Turning to an anti-classification approach, what matters under this approach is whether the government is considering race, regardless of its reason. Under an anti-classification view, the government violates the Equal Protection Clause whenever it takes race into account, whenever it classifies on the basis of race in its decision-making, regardless of whether it does so to dismantle long-standing racial inequalities. Conversely, under this view, the government does not violate the Equal Protection Clause even when its actions create severe racial disparities so long as it doesn't intend to create those harmful effects, so long as it doesn't intend to classify based on race. And these are some illustrative examples of anti-classification language from Justices Thomas and Scalia. You might think of these two views, the anti-subordination approach and the anti-classification approach, as different points on different ends of a continuum. And for sure, some justices and policymakers and thinkers are pure anti-subordination thinkers or pure anti-classification thinkers. And some are somewhere in between. For example, swing justices like Sandra Day O'Connor and later Anthony Kennedy remained reluctant to choose between these competing understandings of the Equal Protection Clause, and they sometimes sought compromise provisions. Now, to be sure, anti-classification and anti-subordination views are not always in tension. For example, the court's decision in Brown versus Board of Education is consistent with both anti-classification and anti-subordination views, as school segregation involved an express race-based classification and at the same time perpetuated traditional racial subordination. The same is true of Loving versus Virginia as another example, which struck down state laws that criminalized interracial marriages. There too, state laws were classifying on the basis of race and subordinating on the basis of race. And for these reasons, Brown and Loving are considered easy cases today because they don't require us to choose between anti-subordination and anti-classification approaches. But sometimes we do have to choose between these approaches. And the need to make that choice is sometimes what makes hard cases hard. And the difference between those choices often drives the outcome. And the two choices differ most fundamentally, in my view, in their attention to the ongoing existence of and importance of addressing long-standing structural inequalities. In my remaining time, I want to take a look at just a few examples of where the choice between anti-classification and anti-subordination makes a difference. McCluskey versus Kemp involved an equal protection challenge to Georgia's application of the death penalty, where the challenger argued that Georgia was administering capital punishment in a racially discriminatory way. There, the challenger relied on what everyone agreed was very sound social science evidence that a defendant in Georgia was much more likely to receive the death penalty when convicted for killing a white victim than a black victim. And the defendant was also more likely to receive the death penalty if he was black rather than white, when all other factors were held equal. But the court's majority held that the Georgia system did not violate the Equal Protection Clause because it found that the challenger hadn't proved that anyone in Georgia, like a specific jury or a judge or a prosecutor, intended that racially disparate result, intended to discriminate on the basis of race, even though the state's capital punishment system had the clear effect of discriminating on the basis of race. And in contrast, the dissent took an anti-subordination view, urging that courts should be suspicious of government actions that perpetuate long-standing hierarchy through their effects alone. Attentive to history and its continuing effects on the ground, the dissent saw today's racially disparate effects of Georgia's criminal justice system as the legacy of the Jim Crow laws that the 14th Amendment was ratified to address. And in so doing, the dissent emphasized the real-world meaning of the statistics. Whether you were sentenced to death in Georgia had a lot to do with race. Mr. McCluskey likely would not have received the death sentence if he had been white, or if he'd been convicted of killing a black victim. So that's one example of how the choice between anti-subordination and anti-classification understandings can determine the outcome in equal protection challenges. Next, let's turn from criminal justice to the educational setting. San Antonio versus Rodriguez involved a constitutional challenge to Texas state law that relied on local property taxes to fund public schools. And under this scheme, which remains very common in the United States, the higher the tax base in a given school district, the more money those schools get. Texas voters in low-income school districts chose to tax themselves at the highest available rate, while voters in wealthier areas chose to tax themselves at much lower rates. Even so, given the difference in the tax base, the poor areas generated less than a tenth of the revenues for their schools generated by wealthier communities. This system tolerates, in fact creates, a system in which wealthy suburban public schools and desolate low-income public schools exist side by side. This system directly disadvantages poorer districts, which include a disproportionate number of students of color. The majority took an anti-classification approach and upheld the school financing system because it found no evidence that the state intended to create these disparate effects with its choice to rely on local property taxes to fund schools, even though, of course, those effects are entirely foreseeable. The dissent, in contrast, urged an anti-subordination approach, where we focus actually works on the ground and whether it has the effect of perpetuating long-standing inequality regardless of the government's intent. And as the dissent observed, this state law has racially subordinating effects by consigning poor kids, disproportionately kids of color, to inferior education that will affect their employment and other life opportunities in ways that continue long-standing patterns of racial hierarchy and subordination. That these neighborhoods are so often separated on race and class lines brings us to one last example, also from the educational context. This is the parents involved case, where the court struck down public school districts' consideration of race when making school assignment decisions in trying to prevent the resegregation of schools. When districts simply assign kids based on where they lived, in many communities we see largely segregated schools because housing patterns remain largely segregated. And to prevent that from happening, school districts in Seattle and Louisville considered a number of factors, including but not limited to race, in accommodating students' requests to be assigned to new schools. The majority took an anti-classification approach in concluding that the school district's consideration of race violated the Equal Protection Clause. That the schools did so because they sought to address longstanding racial segregation didn't matter to the anti-classification majority. It did matter to the dissenting justices who took an anti-subordination approach, who would have upheld the school district's plan because it sought to dismantle longstanding structural inequality. The majority in both parents involved and in Rodriguez before it failed to recognize that segregated housing patterns at the root of the problem in both cases are in fact the result of long-standing government discrimination, long-standing and continuing structural inequalities. The federal government, for example, long guaranteed mortgages in white neighborhoods while refusing to guarantee mortgages, regardless of credit rating, for African Americans, or even to whites who might sell or lease to African Americans. The federal government approved bank loans to finance the construction of new housing on the condition in some communities that none be sold to African Americans. And governments at all levels deliberately chose to site toxic commercial waste facilities in or near African American neighborhoods and to run major highways through those neighborhoods, which in turn drove down African Americans' home values and made those neighborhoods less attractive to whites. These are just a few of the governmental practices that enabled white Americans to acquire home ownership and watch those homes appreciate in value, and thus to build wealth that could be passed on to their descendants, while denying those same opportunities to African Americans. These practices not only perpetuate longstanding housing segregation, which, as we've seen, affects educational and then employment opportunities, but also replicates racial disparities in economic status over the generations. As we've seen, when today's courts and policymakers disagree with each other about how to address discrimination and achieve equality, often it's because they disagree about whether or not to take an anti-classification or an anti-subordination approach to equality problems. And once you think about it, you can see how this would make a difference not only in criminal justice settings and education settings that I've discussed today, but also voting, employment, and more. Note that this choice between these approaches is a choice, though, it's presented not only to the Supreme Court, but it's also a choice available to state court judges, to policymakers at all levels, and it's a choice available to the rest of us. In other words, in thinking about how to address equality problems, voters and policymakers can choose policies and practices that seek to undermine rather than to insulate longstanding patterns of hierarchy and subordination. We can choose, for example, to abandon a death penalty system in which race plays a key role in determining who receives capital sentences. We can choose to fund public schools in ways that provide equal funding to all schools regardless of the race or the class of their neighborhoods. We can choose not to place toxic waste facilities and highways in predominantly African American neighborhoods, and much more. Thank you for your time and your attention, and I look forward to your questions and your comments.
Thank you, Professor Norton. We'll give you a minute to adjust your blinds as the sun seems to be shining on your presentation today. I also want to let everyone know who's participating. This is an opportunity to ask questions of Helen, so you can put those right in the chat, or you can chat them privately to me, whatever your preference is. Okay, we have our first question, Professor Norton, from Walt Frick. Does MLK's dream speech represent anti-classification?
Yeah, thank you for that terrific question. Certainly, anti-classification advocates claim it as their own, and I'm assuming that you're referring to the phrase, among other things, that I hope that someday in the future we won't be judged by the color of our skin, but instead by the content of our character. But of course, at the same time, he was deeply, deeply interested in patterns of subordination, of historic subordination, and was deeply, deeply interested in fighting them. Anti-classification theory, in my view, where you take the optimistic view that if we just stop talking about race, if we stop noticing race, if we stop considering race in our decision making, we will solve the problem of race discrimination, is an ahistoric view. It does not recognize how race has mattered and continues to matter in American life. If we were starting from scratch, and I feel confident that Dr. King, this is the sort of approach Dr. King would take. If we were starting from scratch, if we had no history of patterned discrimination, if discrimination in our world was randomly and arbitrarily assigned, we really didn't know who would be likely to face discrimination, then an anti-classification view makes sense. But if you're operating in a world in which discrimination, subordination, hierarchy has been patterned, where race has made a difference and continues to make a difference in life opportunities, to fail to address those patterns, to fail to recognize that history is both a moral and a policy failure.
Okay, we have more questions. The next question is from Carrie D. Gennaro. Hopefully I'm pronouncing that correctly. Based on the composition of the Supreme Court, do you think advancing racial equality will fall to the states? Or is there a chance this Supreme Court will embrace the anti-subordination theory?
Thank you too, for that's also a terrific question. Well, the majority of the current court is anti-classification in nature. It was before Justice Ginsburg's death, 5-4 with anti-classification theorists in the majority, and 4 anti-subordination theorists in the dissent. And now it looks like I don't know Judge Barrett's views on these, but we'll see. But a majority of the Supreme Court currently takes an anti-classification view. Will that be the federal court's view forever? We'll see. But in the short term, and I appreciate the question to be asking about the short term, again, federal courts are not the only players here. Federal courts are not the only decision makers. Federal courts are not the only actors in the ongoing fight with respect to racial equality. State courts, among other things, interpreting state law, are free to consider this choice anew. And finally, and most importantly, policymakers at all levels, federal, state, and local, and I'm talking about elected officials, and I'm talking about agency heads, and voters have a choice between anti-subordination and anti-classification views. Again, we can choose what sort of death penalty, if any, death penalty system we want. We can choose how we're going to support and fund our schools. We can choose whether or not we're going to tolerate disproportionately disadvantaging African American neighborhoods. That's a decision that's not left only to the federal courts, but is available to all of us.
Very good. Thank you for that, Helen. The next question is from Ruchi Kapoor. When arguing a constitutional due process claim, should litigants be preserving their anti-subordination views? This doesn't seem to be baked in a modern 14th Amendment analysis. It is instead a presumption made when applying the law to the facts.
Well, I think the choice between anti-classification and anti-subordination views is an interpretive choice, and that's what I was interested in the framing of this discussion. Right, we have choices in interpreting various constitutional provisions, including the Equal Protection Clause. Right, it's a broad aspirational clause that leaves us a lot of work to do in deciding what we think equal protection actually means. So the choice between anti-subordination views and anti-classification views is an interpretive choice available to judges and policymakers and voters as well. Now, even though the contemporary Supreme Court is divided, there are anti-subordination views on the court, but a majority of anti-classification views, it hasn't always been so divided. So I think it's, if you're litigating in federal court, I think you need to be prepared to understand there's going to be a debate over the meaning of the Equal Protection Clause, and you should be prepared to couch your arguments in both terms.
Very good. The next question in the queue is from Patricia Peterson. Do you have a concern that if legislators adopt anti-subordination policies, these will be declared unconstitutional by the Supreme Court, which is an anti-classification?
Thank you. I understand that to be a variation on the last question. So again, if we're just predicting outcomes in federal court cases that get to the Supreme Court, I think that's right. A majority of the current Supreme Court is anti-classification in nature. But again, my argument is that the federal courts, including the Supreme Courts, are not the only decision makers, not the only actors, and that jurisdictions, communities, policymakers, voters can choose the policies that they want to adopt. And among other things, they can choose their policies with an eye towards whether or not these policies are in fact replicating ongoing subordination and hierarchy, or instead undermining them.
I think you hit a chord with a lot of these questions. Christian Alexander, excellent presentation. Are there any state Supreme Courts that have known to have taken an anti-subordination stance?
Yes, forgive me, the specific states are escaping me, but state constitutions, right? State constitutions states in their constitutions are free to provide more protections, more constitutional protections than those available under the federal constitution. We see this, for example, with respect to the First Amendment, that some states have free speech guarantees that are even more protective of free speech than the federal courts have interpreted the U.S. Constitution's First Amendment. So, among other things, policymakers can enact statutes that take an anti-subordination view. So, for example, many federal state statutes, some federal statutes and many state statutes prohibit not only intentional discrimination on the basis of race or other protected class statuses, but also prohibit government actions or sometimes private actions that prohibit, that inflict disparate impact on the basis of race. Title VII of the Civil Rights Act of 1964, which is the federal law that prohibits job discrimination on the basis of race. Sex, religion, national origin, and color is an example of this. It prohibits employers not only from intentionally discriminating on the basis of race, but also on choosing employment practices that have the impact of disproportionately disadvantaging folks based on race when those practices don't actually serve valid business objectives. So states and federal legislatures are free to take these sorts of views when they're deciding what sort of policy to enact.
Next, Betsy Crane has a comment. Thanks for your presentation. I really appreciated your laying out the history and various approaches that have been utilized over the years and still are. And then the next question is from Chris Brock. It seems like anti-classification has taken a stronghold over much of our federal courts. Do you see the recent Black Lives Matter demonstrations, protests having an impact on bringing a new wave of anti-subordination views to our society and thus our federal courts?
Yeah, thank you. That's a terrifically thoughtful question. Maybe, right? I mean, you could understand, there's lots going on here, but you could understand part of the disagreement between folks who argue Black Lives Matter and folks who say, no, all lives matter, that is a difference maybe in part between anti-subordination and anti-classification views. And the folks who advocate Black Lives Matter, and I among them, are not saying that other lives don't matter. They're saying we never take the time to notice that Black lives matter, that Black lives have been erased from too much of the discussion, and Black lives have in fact been subordinated and extinguished. So by paying attention to Black lives, you're not diminishing other lives under an anti-subordination view. You are just paying attention to the historical reality that the Black experience in America has been very different. And to the extent that the Black Lives Matter movement is successful in educating folks about this fact, successful in educating folks that include courts and judges and lawyers and policymakers and voters, that might help folks understand the value of an anti-subordination approach.
Well, obviously, Professor Norton, you took a lot of time in preparing your presentation today. And what I was wondering, I had a question, is what is the question you wish people would ask you about your presentation today?
Oh, thank you. That's a nice question. Well, they've done it. They've done it. I would say 3 of the questions you asked me were the sorts of questions that I hoped and anticipated folks would ask me. So there was every speaker should be so lucky to have such a thoughtful audience with such thoughtful questions.
Great. We have a couple more comments. And yes, I think one example of anti-subordination decision by a state Supreme Court is New Jersey's Mount Laurel decision, which makes communities use their zoning codes to promote affordable housing. And I don't know if you want to comment on that.
Oh, no, thank you. Thank you to that commenter. Right. I think once we step back and take a look, we can find many examples at the state and local level, and also on the federal level, not with respect to recent judicial decisions, but in terms of legislation that are attentive to ongoing racial hierarchy and attempt to dismantle it.
Excellent. Well, again, I want to thank Professor Norton for her informative presentation. I imagine that your presentation has prompted a meaningful dialogue for the breakout groups. Next week, all participants will receive a link to the presentation and a survey to share your thoughts with us. And Colorado attorneys will receive a link for a CLE affidavit. Stay tuned for information on this. Now you will be prompted to move to the breakout session. You will need to accept that to be moved in. At the end of the breakout session, towards the end, you'll receive a 2-minute warning that the session is over. We appreciate everybody's participation on this Friday afternoon. Thank you so much.